That was Michelle. Thank you very much. It's time. Good morning. I'm John Rhodes, Chair of the Public Service Commission, and I call this meeting of the Board on Electric Generation Siting and the Environment to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. In Albany, we have Louis Alexander, alternate of Basil Sagos, Department of Environmental Conservation. We have Dr. Elizabeth Lewis-Michael, alternate of Dr. Howard Zucker, Department of Health. We have Vincent Ravashir here, alternate for Eric Gertler, Acting Commissioner, New York State Department of Economic Development and President and Chief Executive Officer Designate, Empire State Development. We have John Williams, alternate of Richard Kaufman, the New York State Energy Research and Development Authority. And I would like to introduce the ad hoc members of the No. 3 Wind Siting Board who are participating from Watertown, Leslie Sheldon and William Schaub. Thank you all. Secretary Phillips, are there any changes or comments on the agenda?
There are no changes, but I would like to just stress or clarify what we're doing here today. We have two different cases that are on the agenda. We will begin with the first case, which is case 16F0328. It's the application of No. 3 Wind. For that case, the Siting Board consists of the members that you just identified. The second item on the agenda today is case 20F0067. It's the matter of rules and regulations of the Board on Electric Generation Siting and the Environment, proposed amendments to Part 1000 and 1001. For that item, the board consists of the permanent board members. So that was to clarify that the Siting Board ad hocs for No. 3 Wind case will not be voting on the regulations in the separate case.
Thank you for that clarification. But they will vote on the No. 3 Wind, which is good. And let's proceed to that. Case 16F0328, application of No. 3 Wind LLC for a Certificate of Environmental Compatibility and Public Need pursuant to Article 10 for construction of a wind project located in Lewis County, presented by Robert Rosenthal, General Counsel to the Siting Board. Chief ALJ of the Department of Environmental Conservation, James McClymans, is also available to answer questions. Mr. Rosenthal, please begin.
Good morning, members. My name is Bob Rosenthal, and I'm counsel to the Siting Board. So the first issue, a matter on the agenda again, is the No. 3 Wind petition for rehearing. So let me start with a little bit of background. On November 12, 2019, this board issued a certificate order for the No. 3 Wind project consisting of 31 turbines to be located on several parcels in the towns of Lowville and Harrisburg in Lewis County, about 30 miles southeast of Watertown. The project developer, NTW, filed a timely petition for rehearing, to which DPS and DEC staff responded, as well as a community group known as THARP. Before you today is an order denying the petition in part and granting the petition in part. The petition for rehearing focused largely on findings related to three issues. First, post-certification compliance requirements for turbine noise. Second, all findings related to the impacts of two protected grassland bird species. And third, the aspect of the order determining not to waive the town of Lowville's local law relating to undergrounding 2.8 miles of a 4-mile transmission line. First, on turbine noise. First, a good piece of news. Neither NTW nor any other party challenged where the board landed on the noise standard. 45 dBA for non-participating landowners and 55 dBA for participating landowners. Again, we view this as a good thing. But NTW did seek rehearing on a more narrow issue, a compliance condition that requires it to use two parameters in its pre-construction noise modeling, a 4-meter assessment point and a 2 dBA uncertainty factor. The order before you denies the petition as it relates to the 4-meter assessment point. The reason is that some of the houses located near the project are 2 stories tall, hence the basis for the 4-meter assessment point. However, the order grants the petition as it relates to the 2 dBA uncertainty factor. The record regarding this issue is complex and ambiguous. In another case, DPS staff determined that post-certification compliance is sufficiently conservative if either a 4-meter assessment point or a 2 dBA uncertainty factor is used. To ensure consistency, and because the 4-meter assessment point is well supported in the case, the order before you grants rehearing for the limited purpose of deleting the requirement to also use a 2 dBA uncertainty factor. Second, NTW seeks rehearing with respect to all findings in the certificate order that the siting of certain infrastructure constitutes an incidental take of the Northern Harrier and Upland Sandpiper. The order before you carefully reviews the findings related to each of the interrelated issues: the determination of a take, the calculation of occupied territory, and the required offset mitigation. And it rules that they are well supported by the record and thus denies rehearing regarding these findings. However, the order considered a new circumstance. That is, on January 1st, 2020, and after issuance of the certificate order, the Climate Leadership and Community Protection Act, or also known as the CLCPA, became effective. One of the key elements of the CLCPA is the mandate on all agencies, including this board, to consider whether issuance of any permits is, quote, inconsistent with the attainment of the statewide greenhouse gas emissions limits. The order before you accounts for the CLCPA mandate by granting rehearing for the limited purpose of giving NTW more flexibility in creating an off-site mitigation plan, including potentially reducing the mitigation ratio to something less than 3-to-1. Third, the petition seeks rehearing on the part of the order in which the board NTW had failed to identify a record basis for waiving the Town of Lowville local law to the extent regarding the undergrounding of 2.8 miles of a 4.4-mile transmission line. On rehearing, NTW points to several pieces of evidence in the record that the board indeed did not consider in the certificate order, including that the incremental cost of undergrounding 2.8 miles of transmission line is about $17 million. Given this record evidence, which was not considered in the certificate order, and the fact that the Town of Lowville, through a local process, agreed to the waiver of its own local law, the order before you grants this aspect of the petition and authorizes such waiver. The remaining aspects of the order address certificate conditions that NTW contests. For example, agency staff agreed to the omission of some conditions which were not included in the recommended decision. On rehearing, the order finds the lack of a record basis for including those conditions in the certificate order. Additionally, including the conditions is unnecessary because the issues addressed in them were either addressed in other certificate conditions or in the SEEP specifications. The order thus requires those conditions to be omitted, but otherwise rejects NTW's request for rehearing regarding omitting other conditions, which the order determines has a firm record basis. So let me make 3 final points. First, agency staff have been working to be more consistent with respect to their positions on certificate conditions and standards. The first part of this decision related to compliance conditions for turbine noise builds on this ongoing process. Second, the CLCPA is now in effect, and it requires this board to ensure that its findings are consistent with the clean energy goals established in that statute, and they are very aggressive clean energy goals. We believe that the CLCPA will play a growing role in this board's decisions moving forward. And third, it has always been this board's intent for developers to work with municipalities. That is what NTW did here, and part of the reason why this order authorizes the waiver of a local law. And with that, I am open to any questions that you may have.
Thank you. My own comments are that obviously I've read the record and the recommendations with care. I find that this is a smart, protective, pragmatic, and as Bob said, consistent resolution on all the issues raised: noise, upland burns, and undergrounding. I commend the staff and the parties, and I'm going to support this item. I turn now to my fellow colleagues and ask them for any comments. Mr. Alexander.
Based on the review of the petition and the accompanying papers, and thank you for the presentation today, I have no questions to ask.
Thank you. Dr. Lewis Michael.
I have no questions to ask.
Thank you. Mr. Ravashir.
No questions.
And Mr. Williams.
No questions.
Ms. Sheldon.
No questions, thank you.
Thank you. And Mr. Schaub.
I have no questions.
Thank you. With that, I will proceed to call for a vote. My vote is in favor of the recommendation to grant in part and to deny in part the petition for rehearing, thereby modifying number 3 WIN's previously granted certificate of environmental compatibility, which was subject to conditions. Mr. Alexander, how do you vote?
I also vote in favor.
Dr. Lewis Michael, how do you vote?
In favor.
Mr. Ravashir.
In favor.
Mr. Williams.
In favor.
Ms. Sheldon.
I don't think a rehearing is necessary. I vote no.
Thank you. Mr. Schaub.
I vote in favor.
Thank you. The matter is approved and the recommendation is adopted. And we'll move to the next item of the agenda. Leslie and Bill, you're welcome to sit and listen, but you can't vote.
Okay.
Thank you.
We will move now to the next item on the agenda, which is case 20F0067, and the matter of the rules and regulations of the Board on Electric Generation Siting and the Environment, contained in 16 NYCRR Chapter X, Certification of Major Electric Generating Facilities, proposed amendments to Parts 1000 and 1001. Mr. Rosenthal will present, and Mr. Rosenthal, please begin.
Thank you, Chair Rhodes. So also for your consideration today is an emergency rulemaking that modifies both the definition of the term revision and related provisions of the regulations adopted to implement Article 10 of the Public Service Law. As explained in the regulatory package before you, application of the existing definition of revision is creating unintended negative consequences, the most prominent of which is to cause unwarranted delays in the permitting and construction of renewable energy projects in the state. These delays potentially render projects uneconomic by jeopardizing their eligibility for a federal tax credit, which expires at the end of 2020, time-sensitive project financing commitments, and achievement of construction milestones needed to maintain rights to interconnect into the state's electric power grid. Absent this emergency rulemaking, the state's goals for deployment of renewable energy resources and reduction of greenhouse gas emissions would be impeded. Because these goals are vital to the protection of public health and welfare, and the existing provisions as applied may cause certificated renewable energy projects to be abandoned, the public interest warrants that the definitions should be modified immediately. Let me get into the details of the problem. The existing definition of revision incorporates a bright line test that is triggered if project components like an access road, transmission interconnection, transmission lines, or turbine are relocated by more than 500 feet. This is a particularly problematic test for wind projects, where turbines associated with a single project can often be located on dozens of sites. It is fairly typical for the developer to relocate project components during construction design phase, which occurs after issuance of their certificate. Additionally, the New York State Independent System Operator determines the location of the interconnection, not the developer and not the utility. And that too can happen after the certificate is issued. A change in location of the interconnection by greater than 500 feet means that the associated transmission lines will also be moved by that distance, thus triggering the bright line test incorporated into the existing definition of revision. That is precisely what happened in the Casadega case with respect to that project, the first project that this board certificated. Because of the bright line test, the certificate process in Casadega had to be reopened, and the project was subjected to an extra evidentiary hearing, despite the fact that the new location for the point of interconnection was found to reduce environmental impacts, and nobody objected to the relocation. To ensure that this does not happen in the future, the new definition of revision and associated changes that are before you today would prevent the reopening of the certificate process for project changes that are environmentally benign or environmentally beneficial. Under the new definition, the bright line 500-foot test would be deleted, and the determination of whether the project is considered a revision would depend entirely on whether the relocation of project components results in a significant adverse environmental impact. To be clear, the applicant would still be required to ensure that any proposed amendment to the application or to the certificate would not cause the project to be out of compliance with certificate conditions. Those would still apply. Under another associated regulatory change, the PSC Secretary, after consultation with DPS and DEC staff, would have 14 days to make a determination regarding whether a project amendment is deemed a revision and thus subject to the additional evidentiary process. Finally, the 500-foot wetland delineation requirement, which is directly tied to the 500-foot bright line test incorporated into the definition of revision, would be changed to 100 feet, which is consistent with the delineation required under DEC's freshwater wetland regulations. Again, the need for this rulemaking immediately is based on the number of projects that have been certificated to date, the fact that the construction season is quickly approaching, and any delay could cause the developer to miss this year's construction season, and worse, the project to be uneconomic and thus abandoned, and the need to site the facilities as soon as possible to meet the clean energy goals set by the Public Service Commission and under the CLCPA. It is also important to note that the goals of and intent underlying adoption of the CLCPA also underline the reasons to move immediately on the rule change. The CLCPA requires by 2030 for a minimum of 70% of the statewide electric generation to be provided by renewable energy systems, and by the year 2040 for the statewide electric demand system to generate zero emissions. The legislative intent underlying these aggressive targets is included in Section 1 of the CLCPA, which is incorporated into this rulemaking. Section 1 touches on the impending climate-related issues impacting New York today, including that, quote, climate change is adversely affecting the economic well-being, public health, natural resources, and the environment of the state. Section 1 of the CLCPA goes on to note the numerous detrimental impacts associated with climate change, including an increase in the severity and frequency of extreme weather, rising sea levels, increased average temperatures, and the exacerbation of air pollution. The purpose of the CLCPA, like these regulatory changes here, is intended to mitigate those impacts. In sum, the identical public health and welfare basis underlying the CLCPA also animates the need to act immediately on this rulemaking. And that concludes my presentation, and again, I am open to any questions with respect to the rulemaking.
Thank you. Again, I've reviewed this item and will have no questions. My own comment is that this is a well-justified and appropriate revision. You know, my own internal language, I call it an improvement. When there are changes to a project that are beneficial, and specifically when they are environmentally beneficial, we should encourage them and not discourage them. So I see this, the purpose of this revision as making sense. I see the timing as of now as making sense. And I find that the specifics of the revision in their clarity and in their narrowness also make sense as well. I'm going to be in favor of this item. Mr. Alexander, do you have any questions or comments?
I have no questions.
Thank you. Dr. Lewis Michael,
No questions.
Mr. Ravishir,
I have no questions.
Mr. Williams.
No questions.
Thank you. With that, I will proceed to call for a vote. My own vote is in favor of the recommendation to initiate a rulemaking process concerning the proposed amendments to the Article 10 regulations, Parts 1000 and 1001, and to adopt the proposed amendments on an emergency basis. Mr. Alexander, how do you vote?
I also vote in favor.
Dr. Lewis Michael, how do you vote?
In favor.
Mr. Ravishir, how do you vote?
In favor.
And Mr. Williams, how do you vote?
In favor.
Thank you. Secretary Phillips, is there anything further to come before us today?
No, there's nothing further.
Thank you. With that, I adjourn us. Thank you very much. And I hope the weather's okay up north in Watertown.
Thank you.
It's clear up here so far today.
All right. Okay. Thank you very much, all.